a nutshell, the family of the deceased hold the view that the maximum sentence provided for under the law should be pronounced, and they acknowledge that whatever the case is, even that particular sentence will not console them or erase their pain. Finally, the probation officer, and again, this is very important, and the court took note of the same. The probation officer, Mr. Andrew Kanyotu, in conclusion and his own observation, says as follows. He describes the accused criminogenic risk factors as follows. That he lacks stable partner relationships. He has antisocial personality patterns manifested by living on the edge. He is impulsive and a thrill seeker. He uses anger or aggression to control others. And finally, he says that the accused has a double personality trait. What is the recommendation in the pre-sentence report? He recommends that the court uses its own discretion in meting out the sentence, taking into account what is in the report, the sentiments of both the accused and the offender. So that's a summary of the submissions by the prosecution, the victim's family, and the accused. So what sentence then would this court be looking at? First and foremost, let's acknowledge where our sentences are provided for. Section 24 of the Penal Code recognizes the following forms of sentences. 1, a death sentence. 2, life imprisonment. 3, or an imprisonment for a term of years. Detention under the Detention Camp Act, if that were the offense committed under that act. And it's important to interrogate these types of punishments, because then one needs to do an exercise of elimination inclusive and justify why this would not be applicable. And so I speak to them for our understanding. Fine, forfeiture, payment of compensation, finding security to keep peace and be of good behavior, and any other punishment this court will find and deem appropriate. So this court cannot give a sentence outside those various recognized forms of punishment. When I consider these categories and types of punishments, I classify them into 2, custodial and non-custodial. So again, the question is, having taken into account the evidence as was adduced in this court, taking into account the submissions at this stage of trial, is this an appropriate case for a non-custodial sentence? I'll deal with that. We have already spoken to the fact that a sentence must serve a purpose. And so what purpose would a non-custodial sentence serve? One of the goals that a non-custodial sentence would serve is to give an accused person an opportunity for rehabilitation. And so, is this accused person eligible for rehabilitation? My answer was in the negative. For simple reason that a person who is given an opportunity for rehabilitation must first and foremost himself acknowledge commission of the offense and the need to reform. Without that attitude, there will be no need to consider rehabilitation. It will not work. He will not appreciate, and of course, then it will be an order in vain. Alongside rehabilitation, we have the goal of reintegration. And when one is considering reintegration, then several questions must be answered. We are releasing this person to the society. Is that safe? Is the society safe? We'll answer that question. What about restitution, restoration? I've already spoken to this and said this is a situation where you are telling the accused person, make good the harm. Is this a case where an accused person can make good the harm in form of monetary compensation? As I was dealing with this particular goal, my mind took me to a case I deal with on a day-to-day basis when I'm dealing with appeals, and more so in civil cases, and someone has come before the court because they were involved in an accident and they suffered bodily injuries. And in the case of Coastal Kenya Enterprise Limited versus Mushiri, is a civil appeal number 84 of 2016. This is what the court said, and which I fully associate with. Money cannot renew a physical frame that has been battered and shattered. And so in my considered opinion, this is not an appropriate case where the sentence that is being meted out is aimed at restitution, restoration, and or compensation in monetary terms. What about reconciliation? Should this court give a sentence that would aim at reconciling the two families? Having listened to me read out the pre-sentence report, it is very clear that these two families are incapable of sitting to negotiate, to reconcile. Where does that leave the court? The court was left with only two objectives to look at: retribution and deterrence. And I've already spoken to them at the beginning of this judgment. That is where the court punishes the offender, at the same time deters the offender from repeating the offense if given an opportunity, and the general public from committing a similar offense. The purpose of law and the aim of law, in my understanding, is to maintain law and order and protect the citizens of a particular state. That is why one of the objectives of sentencing is community protection. And therefore, the sentence any court pronounces must speak clearly to the community condemnation of criminal conduct. At this point, I was drawn, and I'm entitled as a court, to take judicial notice as I talk about and discuss general deterrence.